You're watching Study with Sudhir. My name is S Sudhir. Yesterday evening, the Council for the Indian School Certificate Examination put out its notice on its website. In terms of content, there is nothing new, or at least nothing beyond what we had already spoken about soon after the Supreme Court verdict had come out at around 10:30, 10:45 a.m. The notice spoke about the exams which the students of both class 10 and 12 can take should they want to better their performance, and these exams will be held whenever the situation is conducive. We spoke about the results date of on or before the 15th of July. But there was one fact that actually stood out, and that is what you really need to understand, because it certainly creates a bit of confusion, and I'm going to be reading between the lines. There'll also be a bit of legal jargon, so I request you to listen to this very, very carefully because it can get confusing. Okay, and I have spoken to two legal eagles to understand this better myself so that there is no mistake in any kind of interpretation. What did it say? It said the results of the candidates in the remaining papers in ICSE and ISE will be declared as per the methodology decided and adopted by the CISCE, that's the council. Point number 2, all pending litigation pertaining to the conduct of the ICSE and ISE exams 2020 shall be governed by the order of the Supreme Court and deemed to be disposed of accordingly. Listen to these words very carefully. And the note also had attached the Supreme Court order. Now, what the council is alluding to, is referring to, is point number 8 of the Supreme Court judgment, which says precisely this, that all pending litigation shall be deemed to be disposed of accordingly. Okay. Now, this note of the council, therefore, gives the impression that the sole decision maker of the methodology, or call it formula, will be the council, and no student, no parent, no court has anything to do with it, right? That's the impression which is given if you read just that note. In other words, the case which was being heard all these days, all through June in the Bombay High Court, is history. The question to ask is whether the council is being economical with the truth. Let's examine this and let's put the facts on the table like we always do at Study with Sudhir, and I leave it to you to draw your own conclusions, arrive at your own decision. And as I said, I have spoken to both lawyer Arvind Tiwari, who is a petitioner in the Bombay High Court who had filed the PIL there, as well as senior advocate Rishi Malhotra, who fought the case successfully in the Supreme Court, asking for the cancellation of the CBSE examinations. So what I will say now will contain both their legal inputs as well as, of course, their acumen. Now look at point number 9 of the same Supreme Court order. It says, and I quote, "We make it clear that this order does not deal with any other issue which may arise for consideration in some other proceedings pending before the High Court or this court, except the subject matter of conducting examinations for class 10 and 12 for academic year 2019-20 by CBSE and ICSE respectively." Which means, if there is a case in another High Court, in this case the Bombay High Court, or before another bench of the Supreme Court, that will stay alive except for the subject matter of conducting examinations. Okay, remember this phrase carefully because we will come back to it. What needs to be, however, settled is whether the subject matter of conducting examinations will also cover the marking methodology of the pending papers, and that is what the issue is all about, right? The CBSE has said that we will go by the average of the papers already given, the best 3 or the best 2 as the case may be. We have already done a detailed video on that, and that will be used to mark the students for the pending papers which were to be otherwise held in July 2020. The ICSE is yet to reveal its methodology. It said it has been given 1 week's time by the Supreme Court to upload it on their website, which means on or before the next Friday, the coming Friday. Now, there needs to be legal clarity on that point, whether the subject matter of conducting examinations also includes the marking methodology of the pending papers. Because Arvind Tiwari, the petitioner, makes it clear that the 2 points are listed separately as far as his public interest litigation is concerned, and I'll come to that in a bit. You should also note what happened in the CBSE case in the Supreme Court, because that's an immediate legal precedent. Okay. And I have been following that case very closely, and I have been in touch with Advocate Rishi Malhotra on this to understand the nuances of the case, because you always need to do so that you can simplify it for the viewers. Now, in the case of the CBSE, the affidavit which was filed by the CBSE on Friday morning, which we had put it out before you on Thursday night itself, the 3-judge bench, when the affidavit was presented, the 3-judge bench saw that it also included the assessment formula, the marking methodology, which I just spoke about. Okay. So the judges asked Mr. Rishi Malhotra, the advocate for the petitioners, if he had any objection to the assessment methodology, and he said no. He made another point about students need to be given a 15-day period during which they should say that we need or don't need the examinations. But apart from that, he did not have any objection to the assessment formula that had been arrived at by the CBSE. What it means, and this is important, what it means is that the petitioner's consent or concurrence or nod was secured, and only after that the Supreme Court okayed it, right? So this is an important point, because in the case of the ICSE, the consent has not been secured for any kind of assessment formula. The ICSE was supposed to present it before the Bombay High Court. It asked for a further date saying that it's not ready. Thereafter, it moved the case to the Supreme Court. So it has not presented it before the Bombay High Court, the Chief Justice Dipankar Datta. So in the case of the ICSE, that consent of the petitioner, in this case Arvind Tiwari, has not been secured, despite the PIL of Arvind Tiwari specifically marking the methodology part as a separate point in his prayer. And this is what Arvind Tiwari will harp on in the Bombay High Court on Monday. Now, how is the situation on the ground as far as the legal domain is concerned? I hope you have understood what I have been trying to explain so far. On Monday 29th June at 10:45 am, the 2-judge bench of Chief Justice Dipankar Datta and Justice S Shinde will take up the matter and what could possibly happen. Now, while the council may point to the Supreme Court order, especially point number 8, and say that, the case has been kind of disposed of and no one else is supposed to hear it, Arvind Tiwari, the petitioner, will insist on methodology being placed before the court, saying that the ICSE had promised to do so before the same High Court bench during an earlier hearing. Also, as I said, while the cancellation of the examination part of the PIL has been settled with the ICSE's decision announced in the Supreme Court, the second part of Arvind Tiwari's petition about the marking scheme is still not settled. In fact, there are 2 other parts in the PIL that concern the Maharashtra government and the admission process to the junior colleges, that is class 11, and they also have to be answered, and that will have to be answered by the Maharashtra government. Now, another reason why this methodology has to be cleared is because in one of the earlier hearings, Arvind Tiwari had specifically objected to pre-board marks being taken as the consideration and wanted to know how the whole thing will be computed. But we do know it for a fact that all the 2,600 odd affiliated ICSE affiliated schools have been asked to send the pre-board marks. They did so by the 14th of June. Then the pre-board marks of the previous batch, the 2019 batch, were also sent, I think, by the 19th or the 20th of June. So the data is available with the ICSE, and it looks like the pre-board marks are going to be taken as the base to give marks to assess the students on the pending papers, as opposed to the CBSE. The ICSE lawyer in the Supreme Court making it very clear that our assessment formula is going to be different from that of the CBSE. Now, what could be the ICSE's position in the Bombay High Court on Monday? From what I understand, and this is what the legal brains also think, that the ICSE Council of course moved the case from the High Court to the Supreme Court so that it need not go back to the High Court, and it is more likely to say that the case has been settled, as I said. So depending on the strength of the argument of both sides, the judges will decide in Mumbai. Now, what are the repercussions if the Bombay High Court does not hear this particular case and the case is dismissed on Monday? What happens then? Okay, Unlike the CBSE, there are 3 points here. Unlike the CBSE, which has made its methodology very, very transparent, it's out there in the public domain, students can more or less kind of calculate how many marks they will get in the pending papers, because most students have a fair idea how much they will score in each of the papers they have already appeared for, right? The ICSE will do so only on or before Friday. So unlike the CBSE formula, which was okayed by the petitioner, that is Rishi Malhotra, the ICSE's formula will not be. That's number one. Number two, Rishi Malhotra believes that there could be a window to challenge in case a majority of the parents do not approve or like the ICSE assessment formula. Okay, if they are not happy with the formula, there could be a window to challenge that particular formula. But he says that those petitioners may have to come to the Supreme Court, because the Supreme Court also would like to avoid multiplicity of litigations, and this, since this case of the ICSE cancelling the examinations itself was heard in the Supreme Court first. Now, third point, when the ICSE said it will declare the results on or before the 15th of July, it obviously factored that there will be no more legalities involved, right? But yes, if the High Court insists on hearing the formula of the case, the results date could get delayed as a result. So that is the story as far as the legal drama is concerned. I hope that all this legal jargon and the arguments are clear. So picture abhi baki hai, in a nutshell. Picture abhi baki hai, and whether the end credits will roll out on Monday or whether there will be another episode of this legal web series kind of battle, as it were, we will know on Monday. So stay tuned to Study with Sudhir, and here I would like to actually acknowledge Chiranjeev Datta. He's a subscriber who gave an interesting tagline for Study with Sudhir. He said, it's a case of Seedhi Baat, no bakwas. Okay, so Seedhi Baat, no bakwas. That's the motto of Study with Sudhir. Thank you very much for watching. God bless you.